The law of Congress establishing a territorial government in Florida provided that the legislature of the territory should have legislative powers over all rightful objects of legislation, but no law should be valid which was inconsistent with the laws and Constitution of the United States. Under the power thus conferred, the legislature of Florida passed an act erecting a tribunal at Key West to decide cases of salvage, and, in the case of which we are speaking, the question arose whether the territorial legislature could be authorized by Congress to establish such a tribunal with such powers, and one of the parties, among other objections, insisted that Congress could not under the Constitution authorize the legislature of the territory to establish such a tribunal with such powers, but that it must be established by Congress itself, and that a sale of cargo made under its order to pay salvors was void, as made without legal authority, and pass no property to the purchaser. It is in disposing of this objection that the sentence relied on occurs, and the court begins that part of the opinion by stating with great precision the point which they are about to decide. They say, it has been contended that by the Constitution of the United States, the judicial power of the United States extends to all cases of admiralty and maritime jurisdiction, and that the whole of the judicial power must be vested in one Supreme Court, and in such inferior courts as Congress shall from time to time ordain and establish. Hence it has been argued that Congress cannot vest admiralty jurisdiction in courts created by the territorial legislature, and after thus clearly stating the point before them, and which they were about to decide, they proceed to show that these territorial tribunals were not constitutional courts, but merely a legislative, and that Congress might, therefore, delegate the power to the territorial government to establish the court in question, and they conclude that part of the opinion in the following words: although admiralty jurisdiction can be exercised in the states, in those courts only which are established in pursuance of the 3rd article of the Constitution, the same limitation does not extend to the territories. In legislating for them, Congress exercises the combined powers of the general and state governments. Thus it will be seen by these quotations from the opinion that the court, after stating the question it was about to decide in a manner too plain to be misunderstood, proceeded to decide it, and announced, as the opinion of the tribunal, that in organizing the judicial department of the government in a territory of the United States, Congress does not act under, and is not restricted by, the 3rd article in the Constitution, and is not bound, in a territory, to ordain and establish courts in which the judges hold their offices during good behavior, but may exercise the discretionary power which a state exercises in establishing its judicial department and regulating the jurisdiction of its courts, and may authorize the territorial government to establish, or may itself establish, courts in which the judges hold their offices for a term of years only, and may vest in them judicial power upon subjects confided to the judiciary of the United States. And in doing this, Congress undoubtedly exercises the combined power of the general and a state government. It exercises the discretionary power of a state government in authorizing the establishment of a court in which the judges hold their appointments for a term of years only, and not during good behavior, and it exercises the power of the general government in investing that court with admiralty jurisdiction, over which the general government had exclusive jurisdiction in the territory. No one, we presume, will question the correctness of that opinion, nor is there anything in conflict with it in the opinion now given. The point decided in the case cited has no relation to the question now before the court. That depended on the construction of the 3rd article of the Constitution, in relation to the judiciary of the United States, and the power which Congress might exercise in a territory in organizing the judicial department of the government. The case before us depends upon other and different provisions of the Constitution, altogether separate and apart from the one above mentioned. The question as to what courts Congress may ordain or establish in a territory to administer laws which the Constitution authorizes it to pass, and what laws it is, or is not authorized by the Constitution to pass, are widely different, are regulated by different and separate articles of the Constitution, and stand upon different principles. And we are satisfied that no one who reads attentively the page in Peters's reports, to which we have referred, can suppose that the attention of the court was drawn to a moment to the question now before this court, or that it meant in that case to say that Congress had a right to prohibit a citizen of the United States from taking any property which he lawfully held into a territory of the United States. This brings us to examine by what provision of the Constitution the present federal government, under its delegated and restricted powers, is authorized to acquire territory outside of the original limits of the United States, and what powers it may exercise therein over the person or property of a citizen of the United States, while it remains a territory, and until it shall be admitted as one of the states of the Union. There is certainly no power given by the Constitution to the federal government to establish or maintain colonies bordering on the United States, or at a distance, to be ruled and governed at its own pleasure, nor to enlarge its territorial limits in any way, except by the admission of new states. That power is plainly given, and if a new state is admitted, it needs no further legislation from Congress, because the Constitution itself defines the relative rights and powers and duties of the state, and the citizens of the state, and the federal government. But no power is given to acquire a territory, to be held and governed permanently in that character, and indeed the power exercised by Congress to acquire territory and establish a government there, according to its own unlimited discretion, was viewed with great jealousy by the leading statesmen of the day. And in the Federalist, number 38, written by Mr. Madison, he speaks of the acquisition of the Northwestern Territory by the Confederated States, by the cession from Virginia, and the establishment of a government there, as an exercise of power not warranted by the Articles of Confederation, and dangerous to the liberties of the people. And he urges the adoption of the Constitution as a security and safeguard against such an exercise of power. We do not mean, however, to question the power of Congress in this respect. The power to expand the territory of the United States by the admission of new states is plainly given, and in the construction of this power by all the departments of the government, it has been held to authorize the acquisition of territory not fit for admission at the time, but to be admitted as soon as its population and situation would entitle it to admission. It is acquired to become a state, and not to be held as a colony and governed by Congress with absolute authority, and, as the propriety of admitting a new state is committed to the sound discretion of Congress, the power to acquire territory, for that purpose, to be held by the United States, until it is in a suitable condition to become a state, upon an equal footing with the other states, must rest upon the same discretion. It is a question for the political department of the government, and not the judicial. And whatever the political department of the government shall recognize as within the limits of the United States, the judicial department is also bound to recognize and to administer in it the laws of the United States, so far as they apply, and to maintain in the territory the authority and rights of the government, and also the personal rights and rights of property of individual citizens, as secured by the Constitution. All we mean to say on this point is that, as there is no express regulation in the Constitution defining the power which the general government may exercise over the person or property of a citizen in a territory thus acquired, the court must necessarily look to the provisions and principles of the Constitution, and its distribution of powers, for the rules and principles by which its decision must be governed. Taking this rule to guide us, it may be safely assumed that citizens of the United States who migrate to a territory belonging to the people of the United States cannot be ruled as mere colonists, dependent upon the will of the general government, and to be governed by any laws it may think proper to impose. The principle upon which our governments rest, and upon which alone they continue to exist, is the union of states, sovereign and independent within their own limits in their internal and domestic concerns, and bound together as one people by a general government, possessing certain enumerated and restricted powers, delegated to it by the people of the several states, and exercising supreme authority within the scope of the powers granted to it throughout the dominion of the United States. A power, therefore, in the general government, to obtain and hold colonies and dependent territories over which they might legislate without restriction, would be inconsistent with its own existence in its present form. Whatever it acquires for the benefit of the people of the several states who created it. It is their trustee acting for them, and charged with the duty of promoting the interests of the whole people of the whole Union in the exercise of the powers specifically granted.